Hey, welcome back from break and Happy New Year. 2020 is over. It is finally 2021, and that is something worth celebrating. Woo! And based off of your feedback, it sounds like you guys don't really want me to change that much as we move forward here into the second half of the year. So I'll try not to. So if you can remember back before you took the midterm, which by the way, you guys did pretty well on from what I've seen initially, we started talking about criminal procedure and we looked at the Fourth Amendment and your protections from illegal searches and seizures. And we looked at the Fifth Amendment and due process and all of the rights associated with that. This week, we're going to take a look at the Sixth and the Seventh Amendment, and we're going to dive into what it looks like to be part of a trial. What could you expect if you're ever accused of a crime? What could you expect if you're ever subpoenaed into court as a witness? What does subpoena even mean? Can you expect if you're summoned for jury duty? All that stuff we're going to get to. First time in 2021, cue the intro. Since we're covering two amendments today, let's get right to it and jump into the text of the Sixth Amendment. The Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. As always, I've highlighted the different important elements of that amendment so we can break it down. So that first part says that if any of you are ever accused of a crime, you have the right to a speedy and public trial by an impartial jury. Now, most of you know what a trial is, and we did talk about it a little bit with the Fifth Amendment, but essentially a trial is whenever the government is trying to bring forth evidence to prove you guilty or potentially not guilty of a crime. Even though trials have existed for thousands of years, most of the time throughout history, you were guilty until proven innocent. The Founding Fathers wanted to change that and make a society where you were innocent until proven guilty. Now, there were some sneaky things governments did back in the day to make it look like you had a fair trial, but you didn't actually. One of the things governments used to do back in the day was arrest someone and say, oh yeah, we'll give them a trial, but then constantly delay the trial so that they stayed in prison. See, a lot of people forget that sometimes when you're arrested, you're actually put in prison until you face your trial. Some governments figured, hey, if we delay it long enough, maybe they'll die. So when our Founding Fathers wrote the Sixth Amendment, they wanted to make sure that the government couldn't throw someone in prison indefinitely and then keep delaying their trial. Basically turn that into a very long prison sentence. So they put into the Sixth Amendment that you have a right to a speedy trial. That means the government has to get on the ball and finally hear your case. They can't procrastinate on it, like some of you do with assignments in my class. Now, how long is speedy, you may ask? Well, it depends on the state because states have some flexibility in deciding how long speedy is. However, Congress did pass the Speedy Trial Act, which set the limit at 70 days. That is 70 days after an indictment has been officially filed against you. And that next little part there of the Sixth Amendment says that it has to be a public trial. Another way governments would try to skirt around actually giving someone a fair trial was to make the trial completely private to where no one could really see what was going on. Under King Henry VIII, England had a famous court that did this very thing. In fact, this court pretty much did everything against the Fourth, Fifth, and Sixth Amendments we've already discussed. It was called the Star Chamber Court. In this court, if you were accused of a crime and you went before the judges, it would all be done in secret, and no one would really know exactly what would go on or if you were even actually given a fair trial. More times than not, you were not given a fair trial, and you would be proven guilty by the judges in the court. So the Star Chamber Court was a great way for the king and some of the king's officials to go after people that opposed them or maybe spoke out against them, because then they could execute them or lock them up and then turn around and tell the people, hey, look, we gave them a trial. This is actually exactly what happened to my 15th great-grandfather, Sir Thomas Lucas, who was the Solicitor General to King Henry VII. And when his son, King Henry VIII, took power, he wasn't a big fan of one of his top advisors, a guy by the name of Cardinal Wolsey. So my 15th great-grandpappy decided to say some not-so-nice things about him. As a result of that, he was brought before the Star Chamber Court and found guilty of slander. What exactly went on in that trial, we don't really know, but I can tell you it was not a fair trial. After he was found guilty, he was sentenced to the Tower of London, which we'll learn about next week when we talk about the Eighth Amendment, and let me tell you, bad things happen there. If you've ever been by my classroom, room 513, you'll notice that I don't actually have a doorstop. There's nothing there to prevent the door from banging up against the wall and making a bunch of marks. Okay, well, I should clarify. They did install a doorstop. They just failed epically. So to cover up the dents and marks and prevent new ones from being made, I decided to make my own doorstop. That's right. That's Cardinal Wolsey. That's for you, Grandpa Lucas. Haha, the Lucases really got the last laugh in that feud. And I wonder why my family left England and then ended up rebelling against them in the Revolution. Well, that whole generation that fought in the Revolution, when it was finally their turn to make their own government, they wanted to make sure that trials were public and not in secret, so that if there was any corruption, the public would see it and know about it, and they would be able to hold those people accountable. That's part of the reason why in some trials, the public is allowed in to watch. The media might come in as well. And then sometimes you've got people typing up the transcript of everything that goes on there. All right, so that next part of the yellow highlighted text says by an impartial jury. I know many of you are familiar with what a jury is, but in case you're not, a jury is 12 people sworn to give a verdict in a legal case on the basis of evidence submitted to them in court. So these are the 12 people that have to decide if the accused is guilty or not guilty. These 12 people are selected from the general population, and there's a good chance most of you will be summoned for jury duty someday. So that's why it's pretty important you pay attention to this lesson. And no, you're not put on the list for jury duty when you register to vote. When I say anyone can be selected for jury duty, I really mean anyone can be selected for it.
Just like everybody else, Oprah got wanded down when she was on the jury for a Chicago murder in 2004. In 2015, former President George W. Bush displayed his civic camaraderie in Dallas, though he wasn't picked for the jury. That same year, then-candidate Donald Trump rolled into jury duty in style.
It's a great process. It's the only way to do it. You have to do it.
So here's how the process works. If and when you get selected for jury duty, you'll receive a piece of mail from the government telling you what courthouse you have to show up to and when you have to show up. When you show up to the courthouse on that day, you'll be placed in a room with a judge and a lawyer and a bunch of other potential jurors. They'll then ask you questions like,
Ms. Whitaker, have you ever served on a jury before?
No.
Have you ever been the victim of a crime?
No.
Is there any reason you can think of that you would not be able to decide this case in a fair and impartial manner?
No.
Okay, thank you for your time. Could you state your name, sir?
Larry David.
Mr. David, I'm Counselor Condon.
Counselor Condon, nice to meet you.
Have you ever served on a jury before?
No.
Have you ever been the victim of a serious crime?
My cousin once stole an almond joy from me.
the reason they ask those types of questions is to make sure that they are able to pick people to be on the jury that will be fair and impartial. For example, if you've been the victim of a crime where you've been assaulted before and this is a case involving an assault, then you might be sympathetic towards the victim of the case. That wouldn't necessarily make you a fair and impartial juror because you would be perhaps a little biased towards one side. They'll also ask you questions to try to identify if you have any prejudices, maybe towards a particular race or religion or type of person. And after reading To Kill a Mockingbird, hopefully you know why that's a pretty important part of the process. Not everyone that's summoned is going to end up being on that 12-person jury. That's why they ask these questions, and then they will select people to be on the jury that they think are going to be fair and impartial to that particular case. Back in the day, this is another way government circumvented due process. And they would try to handpick jurors that they knew were going to vote the defendant guilty. Then the government always got the verdict that it wanted. Some people like to brag how they got out of jury duty because they lied or said something really racist that ended up removing them from consideration for the jury. But beware, if a judge catches you lying to get out of jury duty, sometimes the judge can then punish you. I, for one, have never really understood why people want to get out of jury duty. After all, we have thousands of years of evidence of what life is like without impartial juries being selected from the public. But then again, maybe that's just something Lucases are extra sensitive to. Plus, there are some perks to jury duty. No matter what job you have, your employer is legally required to allow you to miss the day, and you get paid for just showing up. That's why I think I'm more in the camp of Stanley from The Office.
I have been trying to get on jury duty every single year since I was 18 years old. To get to go sit in an air-conditioned room downtown, judging people while my lunch is paid for, that is the life.
So once they decide on 12 impartial jurors, that means jurors they think can judge the case fairly and don't have any biases that are going to lead them in one direction. If you're one of those people, they will then notify you that you've been selected to be a juror for that case. Even if you get to that point, there's a high likelihood that there won't even be a trial because of something called plea bargains. Plea bargains are an arrangement between the prosecutor and the defendant, whereby the defendant pleads guilty to a lesser charge in exchange for a more lenient sentence or an agreement to drop other charges. So it's basically the person accused of a crime saying, all right, fine, I'll fess up if you guys go easy on me, or at least easier. So since the defendant is pleading or saying that they're guilty and they're consenting to the government punishing them, there's really no need for a trial. And so you get off the hook. In fact, a study done by the Pew Research Center found that only 2% of criminal defendants at the federal level go on to actually have a trial. Now, if by chance you do end up going to trial, which there's still a chance that could happen, here's what to expect. If you're a juror, you'll sit off to the side with the other 11 jurors. The judge will be seated in the middle, and then directly to the judge's left or right will be a stand for witnesses to be called up to testify. We'll talk more about witnesses in a little bit, but the rest of the courtroom is split. One side is the defendant and the defendant's lawyers, and then the other side is the prosecution and the prosecution's lawyers. So while this might differ depending on the case and depending on the type of court it is, in most cases, both sides, the prosecution and the defense, will start off with an opening statement. And that's where they'll give their initial arguments about why either that person is guilty or not guilty of the alleged crime. After both sides have given their opening statements, both sides then get a chance to actually call up witnesses and question them. The witnesses will then testify, and the lawyers will ask them questions in hopes to try to provide more evidence that either the person is guilty or not guilty. Now, the lawyers from the other side also get a chance to cross-examine. That means ask witnesses from the other side questions as well. Whenever lawyers cross-examine witnesses from the other side, they're trying to ask them questions to poke hole in their story or testimony to make it look like it's invalid. After the witnesses have testified and all the evidence has been presented, then each side will make their closing statements, which is their final pitch to the jury, their final arguments about why you should find the defendant guilty or not guilty. After this, the judge will then turn to the jury and remind them of what the defendant is being charged of and what the potential punishment is if they are convicted.
Listen to a long and complex case, murder in the first degree. A premeditated murder is the most serious charge tried in our criminal courts. You've listened to the testimony. You've had the law read to you and interpreted as it applies in this case. It's now your duty to sit down and try and separate the facts from the fancy. One man is dead. Another man's life is at stake. If there's a reasonable doubt in your minds as to the guilt of the accused, a reasonable doubt, then you must bring me a verdict of not guilty. Now, if, however, there's no reasonable doubt, then you must, in good conscience, find the accused guilty. However you decide, your verdict must be unanimous. In the event that you find the accused guilty, the bench will not entertain a recommendation for mercy. The death sentence is mandatory in this case.
Now, you heard the judge say a really important phrase there. Beyond a reasonable doubt. What does that mean? A reasonable doubt is a doubt especially about the guilt of a criminal defendant that arises or remains upon fair and thorough consideration of the evidence or lack thereof. That means if you as a juror think that there's still a pretty fair chance that someone's innocent, despite the fact that maybe there's at least a little bit of evidence against them, then you need to say that they're not guilty. There has to be an overwhelming amount of evidence that points to their guilt in order for them to be convicted. Because remember, in the United States, you are innocent until proven guilty. Proven guilty is the key phrase there. Meaning not that you're a little suspicious that they're guilty, but that it's been proven that they're guilty. The judge also said that the verdict has to be unanimous. That means all 12 people have to vote either guilty or not guilty. I know some of you in your CTQs like to play the middle road and say, well, I see both sides of it. And maybe that's true, but unfortunately, with some things in life, there is no middle vote. You have to vote one way or the other. And if you're ever on jury duty, you might find yourself in that position. You have to either vote guilty or not guilty. Now, if the jury can't reach a unanimous agreement of guilty or not guilty, then we would call that a hung jury. This results in what's called a mistrial. And with a mistrial, the prosecution can either decide to bring the charges up again or drop them. If they bring them up again, then there's a whole new trial with new jurors that are selected. Now, some of you might be thinking, wait, what about double jeopardy in the Fifth Amendment? Aren't we protected from being tried again for the same crime twice? Not when there's a mistrial. So after the judge has made sure that you all understand that, you're all on the same page about what the expectations are, the jury will then be led into a separate room where you will be put in there to deliberate on the case. That means you discuss the case with the other jurors. Oftentimes, there will be one person that kind of facilitates that debate, and they're called the foreman. The foreman usually starts by taking an initial vote to see where everyone stands. This can be done through a vocal vote, raising of the hands, or by secret ballots. Totally up to how the jury wants to do it. If the vote isn't unanimous, then it opens up for discussion where the jurors on different sides of this can debate why they voted the way they did.
This boy's been hit so many times in his life that violence is practically it's a normal state of affairs with him. I can't see 2 slaps in the face provoking him into committing murder.
It may have been too many. Everyone has a breaking point.
Now, I am going to warn you, just like with anything else in life, you will experience people that annoy you. Even though they try to find impartial jurors, you will still encounter people with prejudice. Whenever there's disagreements on a jury, there's always usually at least one person that thinks they've got it all figured out and they don't want to listen to any facts, logic, or reason. If not everyone's voted with them, they'll get frustrated and they'll let you know.
Well, the vote's 9-3 in favor of acquittal.
I don't understand you people. I mean, all these picky little points you keep bringing up, they don't mean nothing. You saw this kid just like I did. You're not going to tell me you believe that phony story about losing the knife and that business about being at the movies? Look, you know how these people lie? It's born in them. I mean, what the heck? I don't have to tell you. They don't know what the truth is. And let me tell you, they don't need any real big reason to kill someone either. No, sir. They get drunk. Oh, they're real big drinkers, all of them. You know that. And bang, someone's lying in the gutter. Well, nobody's blaming them for it. That's the way they are, by nature. You know what I mean? Violent. Oh, sure, there's some good things about them, too. Look, I'm the first one to say that. I've known a couple who were okay, but that's the exception, you know what I mean? Most of them, it's like they have no feelings. They can do anything. What's going on here?
And sometimes that's what you got to do to them. So if people with prejudice filter through and actually become part of the jury like that guy, it's going to be up to you to stop them. Now, if there are genuine arguments and genuine disagreements within a jury, that's a good thing. In fact, that's one of the beautiful things about the Sixth Amendment and the system of government that we have in place.
That's not why we are here, to fight. We have a responsibility. This, I have always thought, is a remarkable thing about democracy, that we are notified by mail to come down to this place to decide on the guilt or innocence of a man we have never heard of before. We have nothing to gain or lose by our verdict. This is one of the reasons why we are strong. We should not make it a personal thing.
So if you're on a jury and someone challenges your perspective and argues against you, don't take it personal. View it as a chance either to sharpen your own argument and convince other people, or as a chance maybe to change your own mind. So once the jury finally agrees unanimously on a verdict of guilty or not guilty, they will then come back into the court and announce their verdict.
We, the jury, in the above entitled action, find the defendant Orenthal James Simpson not guilty of the crime of murder in violation of Penal Code Section 187A, a felony upon Nicole Brown Simpson, a human being, as charged in count 1 of the information.
That's probably one of the most famous verdict readings of maybe the last century or so, and it's a case you'll learn a little bit more about this week. All right, so moving on with the Sixth Amendment. This next part here says, and to be informed of the nature and cause of the accusation. That essentially means that you have to be notified what you're accused of. And in some countries, like in China or North Korea, you could be thrown in prison and have no idea what you're being charged with for years. Why does that matter? Well, if you're going to defend yourself or have a lawyer defend you, you want to know what you're being charged with so you know how to craft your arguments to defend yourself. In order to say, I didn't do something, you have to know what that something is they're accusing you of. The next highlighted part says that the accused shall have a right to be confronted with the witnesses against them. That means if you get accused of a crime, you have a right to know who accused you of the crime, and you have a right to hear their story in court. It protects you from fake accusations and something called hearsay. Hearsay evidence is evidence based on information received from someone else. So for example, if person A saw person D stabbing his wife and then went to person B and said, hey, I saw D stabbing his wife. If person B then goes to court and testifies and says, hey, A told me that he saw D stabbing his wife, then person B's testimony is hearsay evidence. And that is not allowed under the Sixth Amendment. Instead, person A under the Sixth Amendment would be required to show up in court and testify so that the accused could then be confronted by person A in the evidence that they allegedly have. That way, your lawyers have a chance to challenge that witness and question them to try to defend you and prove their story false. Otherwise, without a chance to cross-examine, whatever their testimony or evidence is might be used against you, and that might be enough to convict you. And speaking of witnesses, that brings us to the next part where it says to have compulsory process for obtaining witnesses in his favor. That means if there were people that have evidence that you did not commit a crime, you have a right to force them to come to court and testify on your behalf. I don't know, let's say theoretically you're at a party and someone accuses you of stealing their dad's signed Pete Rose baseball in their basement. But you never went into the basement. You were outside playing volleyball with some of your other friends the entire time. Well, you could then force your friends to go testify on your behalf, where they can say, no, they were never in the basement. They were outside playing volleyball with us the whole time. Now, there in the Sixth Amendment, it says compulsory. So that means people are forced to testify. So if your friends are kind of like, we don't really want to get involved with this whole thing, well, they don't have an option. Would have to come testify. A court order to testify is often called a subpoena. So if someone ever says they've been subpoenaed to court to testify, that means the court is ordering them or forcing them to come to court and testify. That's why I hinted at that in the Fifth Amendment video where I said self-incrimination doesn't apply if you're being called upon to testify as a witness to a crime. If you're not being the person accused of the crime, then you have to answer the questions. I know oftentimes people get really worried when they get subpoenaed to court and go, I don't really want to get involved, but it's not an option. That's why you also got to be careful who you hang around, because if you hang around someone that's fixing to break the law every now and then, you might find yourself in a position where you're forced to come to court and testify. And that's never fun. And then finally, the last part of the Sixth Amendment says that you have the right to have the assistance of counsel for your defense. That word counsel is another word for lawyer. So this part means that if you cannot afford a lawyer or get a lawyer to defend you, then the government has to provide you with one. This is one of the only times you find the concept of positive rights, meaning that someone has a right to someone else's goods or services in the entire Constitution. The right to counsel or the right to a lawyer is in here because, quite frankly, some of us would be really bad trying to defend ourselves in court. As we learn with self-incrimination and your right to plead the fifth, sometimes we say things that we don't mean to say. Lawyers are supposed to be well-versed in the law. They're supposed to know how it works, and they're supposed to be good at arguing cases. And that could be to your benefit. There's only one problem. If you can't afford a really good lawyer who's probably going to demand a lot of money because they're in high demand because they're really good at their job, and you're stuck with a government-appointed one, oftentimes the government-appointed lawyers don't really have that much of an incentive to win the case. So sometimes the government-appointed lawyers don't do that great of a job as compared to being able to hire a really good one. I mean, you can't really blame the good lawyers if they're so good at their job that a lot of people are in a bidding war for their services, and you can't really blame them for agreeing to take on clients in cases that are going to pay them more money. The government-appointed lawyers, they're going to get paid whether they win the case or whether they lose the case. So that's the Sixth Amendment. And an easy way to remember the Sixth Amendment is Speedy Six. And I always think of a six with a tire as the base of the six, kind of Duna Burna. Then we have the Seventh Amendment, which is pretty straightforward. The Seventh Amendment says that you have the right to a trial by jury in civil cases. Civil law is sometimes referred to as common law, which is the text that is used in the Seventh Amendment. This means there is just compensation for an injury or a wrong. So for example, a property dispute. Now, criminal law is different than civil law. In criminal law, there is often an actual punishment, usually prison or something like that. So in criminal cases, those are cases where a criminal act has been allegedly committed. So for example, an assault, a murder, a theft, a drug possession, or a vandalization. Amendments 4, 5, and 6 deal with criminal procedure with criminal cases. The Seventh Amendment deals with civil cases or civil law. And examples of that would be like property disputes, divorce and child custody proceedings, payment disputes or workplace injuries, etc. According to the Seventh Amendment, if someone is suing someone else for any compensation over $20, then the right to trial by jury is preserved. And you can remember the Seventh Amendment by thinking Civil 7. And that'll do it for this week. So here's your assignments for this week. You have obviously this Ed puzzle and one other Ed puzzle that goes a little bit more in depth with how trials work and the different components in trials. Then you have a Google form that goes through some of the most famous criminal cases in recent memory, and it puts you in the seat of the jury to decide whether or not you think the case was rightly decided. I really encourage you to actually ask your parents and grandparents about some of these cases and see what they think, because I bet they remember what actually happened with some of these. I'm sure they have some opinions on them. I signed the same Google form last year, and students had a lot of fun trying to decide what they would have done and then compare it to what actually did happen. We had great class discussion, so if you want to comment on Google Classroom on the post and discuss the case with other people, feel free to. I might even jump in the comments myself. So your 2 Ed puzzles are due on Wednesday, and then the Google form will be due on Thursday. This week's assignments will be your first grades for the third 9 weeks. Oh, and I did want to mention one last thing. At the beginning of the year, you might remember me talking about the Civic Simulations Club. Well, we just got done doing Guns and Butter, and after the nuke fest that was, we're moving on next to our mock trial. If these last few lessons through the Bill of Rights have really interested you and you've wanted to try your hand at maybe being a lawyer or maybe being a witness or maybe even being a member of a jury, then consider coming to our next meeting, because at our next meeting, I'm going to present a bunch of different cases we can do, and I'm going to let the club vote and decide on what case you all want to do for your mock trial. Then we'll split people up to be lawyers, witnesses, and jurors. Even if you haven't been to a single meeting this year, we would love to still have you. If you do the mock trial and you're not interested in what we're going to do next in the club, then you can hop out if you want. And if you want to join the club or at least maybe figure out when our next meeting is going to be, here is the link to the Google Classroom page as well as the join code. As always, let me know if y'all need anything and have a great first week back.